You ready to speak?
Yes, ma'am.
Ranger Armstrong is your next expert. I
Yes.
presume, Ranger, you understand you're still under oath.
I do, yes, Judge.
And I thought you both agreed that he was an expert. I guess we're not. I don't know exactly in which area. Or am I misspeaking for the state?
The judge, Your Honor, the state found no area in which to proffer Mr. Armstrong as an expert in this case. He was listed on designation of experts, but there was nothing elicited from him that was ever going to be proffered as an expert from the state's perspective.
I'm sorry, I misspoke.
Well,
Go ahead, Mr. Rogers.
Judge, I first ask the court to take judicial notice of I'll get that for you, Judge. Judge, ask the court to take judicial notice of the state's fourth supplemental disclosure of state's experts, in which they list David Armstrong as number 24 on their list of experts.
Well, in which area are you proffering Ranger Armstrong as an expert?
As an expert in use of force, use of deadly force, law enforcement practice and procedures, and the investigation of officer-involved shootings and investigation of homicides.
Use of force, use of deadly force, officer procedures. Did you say homicide investigations?
Yes, Your Honor.
And what was the last name?
Officer-involved shooting investigations and crime scene investigations and
And when you all, or rather Mr. Hermes, when Ranger Armstrong was designated as an expert, in which area did you believe that he may hold expertise?
None, Your Honor. He was designated as such in the event that something did reveal itself, and I can tell you that several weeks prior to trial, I did have a meeting with Ranger Armstrong in which I very clearly expressed to him the state has no intention of calling him as an expert in any matter. I asked him whether or not he...
Okay.
Oh, okay.
That's fine. Then go ahead, Mr. Rogers. Ask your questions of Ranger Armstrong so that we can hear his qualifications and experience in these 1, 2, 3, 4, 5, 6 areas.
Ranger Armstrong, I want to show you what's been marked as Defendant's Exhibit 90. Is that your records from the Texas Commission on Law Enforcement?
Yes, it is. Yes.
And does that show the training that you've received as a peace officer in the state of Texas?
It does.
And Defendant's Exhibit 91, is that a certificate for completion of the investigation of reconstruction of shooting incidents hosted by the Mesquite Police Department in 2012?
Yes, it does.
And Defendant's Exhibit 92, is that your certificate of completion of the Texas Rangers Advanced Crime Scene?
Yes, it is.
Judge, I'll just offer these for purposes of this hearing for the court to review.
No objection for purposes of the hearing.
Okay, you're admitted for purposes of this hearing.
Ranger Armstrong, I know I got into some of your qualifications earlier, but I wasn't, well, now we're in a hearing, and so I want to kind of go through that and elicit some more details. First of all, how long have you been with the Department of Public Safety?
For nearly 17 years, 16 years and 10 months.
And how long were you with Texas Highway Patrol?
For a little over 8.5 years.
And through the Department of Public Safety, before you became a member of the Texas Highway Patrol, what kind of training did you receive?
We received the 6-month basic Trooper Academy in Austin at headquarters. Within that academy, we went through a host of training topics covering the Penal Code, the Code of Criminal Procedure, the Health and Safety Code, Transportation Code. We're also taught basic crime scene investigation, basic accident investigation, basic accident reconstruction, arrest and control tactics, shooting, pursuit driving, things of that nature.
And since your graduation from the academy, as part of the requirements of Texas Commission on Law Enforcement, have you kept up with your regular training?
Yes, I have.
And have you done additional training in regard to the minimum requirements?
Yes, I have.
And with regard to use of force, tell me about your training and experience that qualifies you to be an expert in use of force and use of deadly force. Combine those.
Yes, sir. It's basically my continuing education starting from our basic Trooper Academy back in 2002 until now. It covers Chapter 9 of the Penal Code. It covers all the appropriate procedures and laws that translate to when and how and why to use deadly force or force. It also differentiates the two. It goes into the tactics, the proper application of those techniques, and it also goes into the science behind those techniques, as well as studies that will basically, I don't want to say certify them, but lend weight to how effective they can be.
And at some point, did you become part of the SWAT unit for the Department of Public Safety?
I did.
And tell the court, before the record, what is SWAT?
SWAT is Special Weapons and Tactics.
And what is that unit? Where is that unit located? How do you become a member of that unit? And what is your training to qualify you for that unit?
That unit is based out of Austin at our headquarters, DPS headquarters. Became a member of that unit back in October of 2007. In order to become a member of that unit, you have to go through a 3-day selection course, which during that course they evaluate how you respond to certain types of use of force incidents, how you are able to manage stress and different types of stress, especially under mental and physical just being tired all the time, basically, for lack of a better term. They create different scenarios to see how you can respond when you are lacking in sleep, in energy, food, water, and when everything counts during a stressful incident.
And in addition to that training, when you were as a part of the SWAT unit, did you respond to numerous incidents where you encountered individuals with weapons, individuals that were dangerous threats, individuals that might not have had weapons that were dangerous threats?
Yes, I did.
And based on your personal experience and your training, can you testify as to the physical and mental effects of those encounters on someone in law enforcement?
I believe so.
And have you applied that knowledge and that training and that experience in your investigative role with the Texas Rangers?
Absolutely.
And how long have you been with the Texas Rangers?
For a little under 8 years.
And for the record, what is the Texas Rangers? What do they do as part of the Department of Public Safety?
We are the lead criminal investigative agency for the state.
And you're assigned to Company B, Garland?
That's correct.
And What type of offenses do you investigate?
Mostly violent felonies, also public corruption, which includes, those violent felonies will include aggravated assault, sexual assault, aggravated robbery, kidnapping, homicides, officer-involved shootings.
How many investigations of violent felonies have you been a part of?
It would be hard to put a hard number on that. I would say over 100.
Over 100 easily, correct?
Yes, sir.
And with regard to, with the Dallas Police Department, you have, a homicide unit, an aggravated assault unit, you have a child abuse unit. Texas Rangers, do you investigate all of those?
Yes.
And assist local law enforcement when they need help with some of those as well?
Yes.
With regard to the Texas Rangers, in addition to the training and the continuing education you received as a trooper and with the SWAT unit, while we're on the SWAT unit, are you currently a member of a tactical team?
Yes, I am.
And what is that?
That's the special response team. That is our, what we would call a part-time SWAT team for the northeast region of the state.
And part-time kind of downplays it, but that is a unit that has to be tactically ready to perform SWAT functions. Is that correct?
That is correct.
And do you maintain training and ongoing training in order to be ready for the SRT?
Yes, I do.
And are you an instructor?
Yes, I am.
And tell the court what you do as an instructor for the SRT.
I instruct in close quarters battle, which is commonly referred to as CQB, which is how to clear a room, low light, no light techniques, firearms usage, rural operations. That's the primary ones that I instruct.
And you train the members of that team to be able to respond to quickly evolving, highly dynamic, stressful, tense encounters with violent suspects. Is that correct?
Yes, I do.
With regard to your role and responsibility with the Rangers, what training specifically do you have? The judge has your certificate in advanced crime scene. What is that training?
That is the 3-week school that I mentioned earlier, where we go through a week of photography training, taking still and digital photographs, using video recordings as well to document a crime scene. We will also go over interview and interrogation techniques. We will also go over basic crime scene collection and documentation and the do's and don'ts of collecting that evidence and not contaminating it and messing with the credibility of what we seize.
And with regard to the investigation of homicides and officer-involved shootings, can you tell the court about your training, the special training that you've had, in addition to everything else that you've had in the highway patrol, SWAT, your continuing education, the advanced crime scene, about the additional training and experience you have in the investigation of homicides and officer-involved shootings?
We receive homicide investigation training as well throughout our continuing education in the Rangers. Also, I went to the shooting and reconstruction school. I've also been to the many interview and interrogation schools that will help us to elicit the information from different individuals throughout a homicide or officer-involved shooting investigation.
Have you filed cases in that capacity for the Dallas County District Attorney's Office?
Yes, I have.
And have they accepted your cases?
Yes, they have.
With regard to this case, how did you why were the Texas Rangers called in to investigate this case?
I believe because the circumstances were so extraordinary and they were looking for a third party to conduct the investigation outside of Dallas County DA's office and Dallas PD.
And were you selected by your chain of command to be the lead investigator in this case?
Yes, I was.
You have the full faith and authority of your chain of command to make investigative decisions based on your training and experience, and their trust in you. Is that correct?
That's correct.
With regard to your investigation of this case, did you apply all these skills, techniques, training, and experience in your investigation of the events that occurred at the Southside Flats on September 6, 2018?
Yes, I did.
With regard to the experience of an officer that is responding to a tense, rapidly evolving, dynamic encounter with a suspect, can you tell the court, based on your training and experience, the physical sensations that the body is experiencing when encountering a suspect in that tense, rapidly evolving, dynamic situation?
Sure. A person in that situation may experience a very rapid heart rate. They may experience auditory exclusion where they can't hear as well. They also may experience vision narrowing where their peripheral vision is not as efficient as it normally would be without that stress. They can also lose some short-term memory as to what may have happened, and it's usually restored as time goes on.
And is that what you just told us, that based on your personal experience?
Yes, it is.
Is it also based on your experience in the training that you've received in shooting incident reconstruction, homicide, and your training over the years?
Yes, it is.
And is it also based on your investigation of officer-involved shootings, interviewing officers, reviewing hundreds, if not thousands, of body cameras or dash cameras, or audio recordings? Is that consistent with your investigation experience as well?
It is.
What is the application of that in this case? You interviewed Amber Guyger, correct?
That's correct.
Did she describe an encounter with a rapidly evolving, dynamic, tense encounter with what she believed to be a suspect?
Yes, she did.
And what, in those situations, is it common that you see for a person to focus on when dealing with a threat?
Can you re-ask that, please?
Sure. When someone in law enforcement is, and based on your training and experience, is encountering a suspect, as Amber Guyger did in the apartment of 1478 on September 6, 2018, did she describe some details that were consistent with your training and experience?
Yes, she did.
And what were some of those?
Some of those were the narrowing of the vision, the confusion, and
let me go with narrowing of the vision.
sure.
What is it in your training and experience when someone is confronted with a threat? How does this narrowing of the vision portray itself and affect the decision-making of the officer that's encountering the situation?
It's almost as if you're in a hallway with walls and you can't see what's on the other side of those walls. And you can only see what is in that hallway. So the perceived threat would be somewhere in that hallway, and everything to the sides of it, to an extent, is kind of drowned out because of the physical stress that's being felt.
And in this case, if her attention narrowed to the suspect, who she believed was a suspect, we know he wasn't, but who she believed as a suspect, is that a rational response for her to have tunnel vision or narrowing of her vision and hyper-focusing only on that individual?
Yes.
And that her decisions are going to be made based on that hyper-focus. Is that fair to say?
Yes, it is.
With regard to the difference between responding to a burglary call or encountering a suspect in your own home, is there a difference?
Yes.
And is there, when you're encountering, when you train your SRT members, when you've had training in SWAT, when you've experienced these situations in SWAT, and you go from a non-dynamic, relaxed situation to a suddenly, quickly dynamic situation, explain to the court what everything that is going on that an officer is having to react to make decisions.
You are trying to, one, make sure that what you do is safe and immediately necessary to counteract whatever perceived threat that you have. Whether that be moving, whether that be communicating with your teammates or whomever may be there with you, or not at all, or whether it may be trying to use another piece of gear to enhance what you're seeing if you have that available to you. You're trying to apply the appropriate tactic, all while observing and orienting yourself to your perceived threat, and then deciding what course of action you need to take, and then taking that action. That is a process that occurs extremely quickly, and in my experience, it's been, we're talking a few seconds if you're lucky. So you're trying to do that depending on what your perceived threat is, depending on what the environment is, and depending on what tools you have available to you.
In this case, was Amber Guyger responding to a burglary call?
Yes.
Well, was she on duty responding to a dispatch burglary call?
No, sir.
Did she confront, or was she, did she, in entering into what she thought was her apartment, enter into a confrontation with what she believed to be a burglary suspect?
Yes.
And tactically, what were her options at that time?
Her options at that time was to treat it as if countering an ambush. And there's very few choices in countering an ambush. It's either to go around it, either to back out if possible, or to assault it.
And the backing out option, based on the hallway and the wide open hallway, and encountering a suspect that she believed had broken into her home and was rapidly approaching her, is that always a sound option? Was that a sound option for her?
I don't believe so.
Why is that?
Because backing out with the amount of gear that she had in her hand, her perception that he was coming towards her, and the fact that the door was open, but he would still been coming at her. I believe she felt that the distance was so close and it was immediately necessary to have to use the force that she did. I believe that she perceived that it would be ineffective for her to back out rather than to use force at that point.
based on, let me ask you this. Do you have an opinion as to whether or not Amber Guyger's actions in using deadly force were reasonable?
Yes, I do.
And what is your opinion?
My opinion is based on the circumstances, the totality of the circumstances in our investigation, that they were reasonable at that time.
Ranger Armstrong, based on your investigation, which included your interview with Ms. Guyger, your interview with several witnesses, looking at all the police officer affidavits, looking at doing the canvass of the Southside Flats, looking at all the circumstances that were available to you in your investigation, do you believe there is probable cause that Amber Guyger committed murder without justification?
No, I did not.
Do you believe, based on your training, experience, and background, and looking at every piece of evidence in this case, that there is probable cause that Amber Guyger committed manslaughter or criminally negligent homicide without justification?
No, sir, I do not.
That was the extent of my proffer, Judge.
Well, do you or Mr. Glass?
I'll examine Ranger Armstrong. May I proceed, Judge?
Yes, please.
Ranger Armstrong, so basically, if I've gotten this right, you basically want to offer opinions based on two different broad categories. The first category is that you believe that Amber Guyger's use of deadly force was reasonable.
Yes.
And the other broad category is that you believe that Amber Guyger believed that deadly force was reasonable.
Yes.
Is it fair to say that all of the background that you've just discussed, the particularities of it, are going to go to offering an opinion on those two broad subjects?
I believe so. Yes, sir.
Okay. So let's just talk about that. Tell me, first and foremost, what is your definition of reasonable belief? Since you would want to opine an opinion that you believe that her use of deadly force was reasonable, what is your definition of that?
I would believe that a reasonable belief would be one that is, when weighed with all of the circumstances present at the time that that belief is formed, that other people in that same set of circumstances in that environment could or would make the same choice as the person that has that belief.
So let's talk about some of the that you discussed with. Okay. So it began with first of all, so you would not be offering any opinion, if I understand the limitations that Mr. Rogers has just discussed, any placement of any of the individuals involved within the apartment. Is that right?
I'm sorry, ask that please again.
I said, understanding the limitations that Mr. Rogers has sought to qualify you, you are planning on not offering any opinions as to placement of any individuals within the apartment. Is that accurate?
If I was asked, I would offer it.
So you actually have an opinion on that too?
I do.
Hold on one second. Will you have Deputy Johnson and yourself to retire the jury? Because apparently this has gone on a little longer than we anticipated. I'm sorry to have interjected at that time.
Sure, Judge.
Judge, just to be clear, I mean, I know he said he'd answer a certain way. I'm not proffering that opinion in this hearing.
Okay. Fair enough. Then
We're
let's
not
talk.
proffering, so you have no intentions whatsoever to question him about the placement of the persons at the time Mr. Jean was shot.
Based on the court's previous rulings, I'm not going there, Judge.
Okay. And just so we're clear, you will also not be asking any questions about whether or not Ms. Guyger's actions were reasonable.
Well, that's exactly what.
It was just what I asked on the record, Judge. It's what.
I know, but he gave an opinion about murder, manslaughter, and criminally negligent homicide, and that her actions were reasonable. And the court is of the opinion that the reasonableness is a determination to be made by the jury. Thus far, I believe Ranger Armstrong can tell us about the physical sensations one might experience when encountering the suspect, but we have the state has not proffered Ms. Guyger's statements, so there would not be any questions about what she told them.
Right.
Just general person's experience and not particularly Ms. Guyger's experience. Well, that's what I've checked off so far. I hate to keep interrupting.
No, that's fine, because I was going to go into everything else, but if that's the only thing that the court
Well,
says.
that's where I am so far, but that doesn't mean I have everything right, so I'm
Okay.
listening.
Well, if I may then just proceed on that, Judge.
Yes, please.
When it comes to, let's just speak specifically then about potential sensations that a person may have. You said that you were basing that on personal experience and experience that you've seen in other law enforcement officers, right?
Yes,
But you don't know what Amber Guyger's experiences are. You don't know what she felt.
that's correct.
She can testify, as she did, about what she felt, which would be relevant to her state of mind. Right?
Yes, sir.
You would just be speculating based on how you have responded to stressful situations and what you've seen other officers, some other officers. I mean, very anecdotal evidence. Is that correct?
Not necessarily. I'd be basing those based on what either I observed them go through or what they told me they went through, and the same in Ms. Guyger's case.
Right, but with Ms. Guyger, she can actually say what her sensations were, and she did.
Correct.
Okay, so when it comes to what Ms. Guyger, her sensations were, she alone can say what those sensations were.
Yes,
You can only testify to what you might perceive and may have perceived in the past, which may be different than Ms. Guyger.
that's correct.
And you can say what some other officers that have shared with you about their experience, and their experience may be different than Ms. Guyger.
That's correct.
You're not going to suggest, Ranger Armstrong, that you know how she perceived and how her sensations were on this particular case.
No, sir.
She would know that.
That's correct.
So for you to be saying some of the things that other officers and you feel, you may be giving her some sensations that she never experienced in this particular case, right?
No, sir. I'm basing what I feel she perceived on the statement that she gave me. I'm not adding to that, and I'm not taking away from it.
Understand, but she has testified in this particular case about what her sensations were.
Yes, sir.
Okay, and what she has told you would be, her statement of her own opinion, which she can share with the jury.
Yes, sir.
All right. So you can't say with any degree of certainty what she actually felt. Right?
That's not what I'm trying to say, though.
Well, let me just say this. I can tell you right now that I feel happy, but you don't know if that's true, right?
That's true.
You can say that I said that.
Correct.
All right. But if I wanted to, I could tell the jury how I felt if I wanted the jury to know.
Yes.
You would be speculating if you were to say, this is what Miss Guyger felt at any moment in time.
Correct.
Okay. You were talking about how you might be able to assist the jury when it comes to use of force decisions because you're familiar with Chapter 9 of the Penal Code and how the law works. Is that right?
Yes, sir.
Okay. Well, you understand that is up for the court and the court alone to instruct the jury on the law and how the law applies in this case.
That's correct.
All right. So, do you have some knowledge of the law that would be different, or that you think that the court, do you have some knowledge of the law that the court won't be able to handle?
No, sir.
All right. You were talking about some experiences with SWAT where they were lacking in sleep, food, and water, correct?
Correct.
Scenarios that individuals were lacking in sleep, food, and water. Again, this is going to be personal, anecdotal information passed on to you from people who had certain experiences, right?
In addition to my own, yes.
Okay, and yours. But again, Ranger Armstrong, you understand that you're not going to be testifying about how the facts that she experienced affected you.
That's correct.
All right. The relevant thing is, what did Amber Guyger perceive, and whether or not these jurors find that to be objectively reasonable under the law? Right?
Yes, sir.
Okay, so...
Hold on, Mr. Holmes.
Yes, ma'am.
The bailiffs have just reminded me that I need to admonish the jury before they retire for the evening,
Yes,
so
ma'am.
give me just a few moments.
Thank you, Judge. May I proceed? I don't have much more. All right, so Ranger Armstrong, then you had gone through a lot of information about, your training and experience when it comes to investigating cases. So you do certainly have an acumen for obtaining facts, right?
Yes, sir.
Okay, and with those facts, you turn those over for an investigation so that our criminal justice system leaves opinions of what those facts mean to a grand jury and then ultimately to a jury or to a judge, right?
That's correct.
So that's the role of an investigator, is to derive facts and present information to people who are fact finders.
Absolutely.
Okay. So with respect to moving beyond the pale of an investigative rule, you also tend to offer the following. You said that an officer responding to a tense encounter with a suspect, Mr. Rogers asked you, well, what does the body experience? And your answer to him was, that person may experience rapid heart rate. May.
Yes.
Not certainly,
Correct.
not never.
Correct.
So again, speculating about how it belongs to anybody generally, right?
Correct.
And certainly you can't testify what Ms. Guyger's heart rate was doing at the time, is that right?
That's correct.
You said that the person may have auditory exclusion.
Yes, sir.
May.
May.
Not always,
Correct.
not never.
Correct.
And you certainly can't testify as to whether or not Ms. Guyger had any auditory exclusion.
No, I cannot.
You said that the person may have vision restrictions.
Yes, sir.
Not always,
Correct.
not never.
Correct.
Again, speculating as to what the statistics within a community are, right?
Correct.
But you certainly can't testify with any kind of clarity or certainty as to whether or not Ms. Guyger had vision restrictions, or if so, to what extent.
No, sir, I cannot.
So again, you could testify maybe in one of your officer-involved shootings how you were affected by either rapid heart rate or auditory exclusion or vision restrictions, but that's your experience, right?
That's correct.
You also said that a person can have short-term memory issues.
Yes, sir.
And can is like may. You can't testify that Ms. Guyger had any short-term memory issues whatsoever.
That's correct.
So again, all of this, if you were to offer these facts to a jury, would be idle speculation as to how they actually play any part in this particular case.
Yes, sir.
You've also talked about, I guess, with the visionary restrictions about the concept of tunnel vision. Again, Ms. Guyger could talk about what she saw in this situation, right?
Yes, sir.
To the jury.
Yes, sir.
And you can't say what Ms. Guyger saw.
No, I cannot.
And then you were talking about response to your own home versus whether or not you're dispatched on a call. You can again talk about what you would do if you encountered a burglar at your home.
Yes, sir.
You can't say what I would do if I encountered a burglar in my home.
That's correct.
And you can't tell me what I think is reasonable about how to handle a burglar in my home.
Correct.
just like you can't say for Ms. Guyger.
Correct.
I mean, okay, so I think I could probably just do this with all of the stuff that you've talked about. At the end of the day, I think I just want to, again, focus this on the two broad areas where you want to offer an opinion. And that would, number one, be that you believe personally that Amber Guyger's decision to use deadly force was reasonable.
I believe professionally, yes.
Okay, you and your professional, personal belief. That's David Armstrong
Yes, sir.
believes that.
That's correct.
Okay? And you believe that Amber Guyger believed that deadly force was reasonable.
Yes, I do.
Okay. And those really are the broad umbrellas upon which you want to offer an opinion.
That's correct.
Okay. Judge, okay, that's all I have. I'll pass the witness back to Mr. Rogers.
Just to be clear, no one, Mr. Hermes can't say what was in Amber Guyger's mind, correct?
That's correct.
But he's going to argue it. He's going to argue what was in her mind. And so you provide a perspective based on investigating hundreds of violent criminal offenses, of being involved in similar situations, in training officers in similar situations, in observing, experiencing, and investigating cases where all these factors are at play. You provide that perspective and that expertise that the Texas Rangers are called upon to in this case, and that you express that expertise and opinion to this district attorney's office and other district attorney's offices in your experience, correct?
That's correct.
And the state of Texas represented on a list that you were an expert, correct?
Correct.
Now, when you've told your opinions to Mr. Hermes, correct?
I have.
How did he respond when you told him that?
Are you talking about today or the past?
No, the past.
There's never been objections before this.
Right. So no, he's offered your opinion in other cases, correct?
Absolutely.
When you told him your opinion in this case,
Judge, I'm going to object to that. I don't think Ranger Armstrong has ever expressed an opinion at my request to a jury.
I didn't say that.
But that's what we're here for, Judge.
No, I asked if you relied on his opinion in other cases.
Your Honor, I just object to Mr. Rogers saying how I felt. I will certainly listen to the opinion of any investigator, and I may agree or disagree, but that...
I'll move on.
Thank you.
How did he respond when you told him in this case what your opinion was?
He disagreed.
Was he angry?
That'd be hard for me to say.
You're not trying to say that you know what goes through Amber Guyger's mind, but you can tell based on everything we've gone through, you have information that will assist the trier of fact with understanding the common experience. And we're not talking about some or a few. We're talking about these things that you've seen over and over and over in your, from Highway Patrol to Texas Rangers, that a person experiences in these situations.
Yes, sir.
That's it, Judge.
Do you have anything else, Mr. Hermes?
I have no other questions, Your Honor.
Do you have any objections to Trooper Ranger?
Yeah, Your Honor, I do.
I'm sorry, Ranger Armstrong.
Yes, Judge, the state renews its objection under 705 to all of Ranger Armstrong's testimony. He's not qualified in relevant areas of expertise to this case. The testimony that he's proffered is neither reliable nor relevant to assist the trier of fact in this case.
Well, the court will allow Ranger Armstrong to testify concerning the physical sensations that a person might experience when encountering a suspect. Not that Ms. Guyger experienced, but that a person might experience based on your training, experience, and other investigations. But the court will not allow and does not wish to be surprised about any questions determining that go to the reasonableness of Ms. Guyger's actions and your belief that they were, or your belief that Ms. Guyger believes that her actions were reasonable. The questions concerning the reasonableness of the defendant's actions will be determined by the triers of fact. Am I clear?
Yes, Judge.
Yes, Your Honor.
And I would like to just make sure I'm very clear on this. So Ranger Armstrong's testimony is going to be limited only to physical sensations that may be encountered, that a person may experience when encountering a suspect, and that's going to be the extent of what is allowed under Mr. Rogers' proffer.
Yes.
Okay. And Your Honor, there's a motion in limine concerning the defendant's statement.
I'm not mentioning.
But I'd like the court to please instruct or make sure that Ranger Armstrong is aware, because I do know that during this proffer that was mentioned several times. I don't want that to escape. Could you just remind the witness of that particular ruling?
Yeah. Ranger Armstrong, Ms. Guyger's statement is not in evidence, and it is not to be referred to or alluded to in any fashion.
Yes, Your Honor.
And Your Honor, just one other very clear, one more point of clarification. While Ranger Armstrong is going to be allowed to testify as to general feelings that people may experience, is that going to be limited to just generalities, or are you going to allow him to indicate that in some way Ms. Guyger felt any of those?
I think I was clear.
You were
Let me
clear,
be
Judge.
Yeah. I think Mr. Rogers understands. And Ms. Guyger has told us what she has felt. She's the best witness for that. But no, he will not speak to what Ms. Guyger may or may not have felt. He's going to educate the jury about what other persons, including himself, that they may have experienced a rapid heart rate. Maybe not everybody. They may have had auditory exclusions. Some people, not everybody. They may have had vision restrictions or narrowing, and they may have some temporary loss of memory. That's what I gathered. He stated that based on his training experience and multiple investigations, those have been the physical sensations that persons have experienced.
All right, Your Honor.
Did I miss something?
No, Judge, and then I would just like to ask him what his experience is with perceptual memory.
Judge, I object to that. Again, that would be going into his personal experience.
Well, his experience and everything, everything that he has elicited from other officers and everything that he's observed throughout all his career that I've got.
Well, we can't do everything that he's observed. We've
Yeah.
been here forever.
That's why I just want to talk
He gave
about
us a
perceptual.
general description about how persons' hearts
Right.
can rapidly increase. He said it wasn't common to everybody, but some
Right.
people may have that sensation. He told us that some people may have auditory exclusion where there's only certain things that they hear and or perceive. Is that correct?
Yes, Your Honor.
And you stated that some persons might have vision narrowing or vision restrictions. You described it as tunneling or tunnel vision. I think he said narrowing and or restriction. And he told us that some persons might have a loss of memory, and he said that was typically temporary. Now, is that correct?
I believe I said it could be restored through time.
So, Judge, I understand the court to be saying that
Generally speaking.
yes, but Mr. Rogers is now wanting to ask if Ranger Armstrong could
We
give
talk about his
personal experience.
I'll rephrase it. I just want him to explain what is perceptual narrowing.
Judge,
Is that the vision narrowing
Right,
or
the vision
restriction?
narrowing. Yes.
but Judge, We would object that Ranger Armstrong is not a qualified expert on what visual narrowing is outside of his own experience. He's testified to no basis for understanding what the medical principle or psychological principle
He just
of
described
visual narrowing is. He said what he's experienced when he feels he has tunnel vision. So that's outside of his realm of qualifications as any kind of expert.
Judge, I thought you already ruled that he could talk about, not about his personal, but general on that very subject, which is,
I will let him testify generally about, now you went and said you want to hear about his personal experience with
I just want him to be able
to explain to
explain
the jury
what tunnel
what
vision is.
vision restriction or narrowing or tunneling or tunnel vision
Right.
is.
Yes, generally.
General. Do you understand that?
I do, Your Honor. Yes, ma'am.
Oh, your objection is overruled. I will let him give a general explanation of vision narrowing, vision restriction, and/or vision tunneling, whichever phrase you all choose to use as it relates to them.
And Judge, while we're outside the presence of the jury, can we board out the Ranger on the basis for that specific knowledge for vision tunneling?
Sure, yes.
Thank you. Ranger Armstrong, what is the basis for your understanding of what vision narrowing is?
It's going to be from the training that I've received throughout my career as it relates to investigations and the tactical work that I've performed.
What training is that?
It's going to be, as I've stated before, many firearms courses I've been to, CQB, active shooter. They speak on those topics because those are characteristics that can be experienced by people that are in those environments or in those situations.
Okay. At your firearms course, who speaks on the topic of vision narrowing?
The instructor.
And what does the instructor tell you?
The instructor tells us that they will try to replicate that throughout the course of fire by trying to get our heart rate up to the point where vision narrowing may occur. And it will allow us, it may allow us to experience it, it may not. It just depends on the individual, depends on their physical fitness level. There's many, many different things that it can depend on.
So if I understand that right, the instructor is telling you that he's going to create vision narrowing for you.
He's going to try to create it for each of the students
Right.
at once, yes.
So when you're at the firearms school, what you're experiencing from the instructor is the sensation of vision narrowing. Is that right?
I'm sorry, can you ask that again?
When he elevates your heart rate, you experience vision narrowing?
It depends on, he doesn't elevate my heart rate. It depends on the activity that we
Okay.
that we do in order for your heart rate to increase.
But does he tell you what vision narrowing is?
Yes.
What does he tell you that it is?
Just as I explained earlier, that you begin to lose peripheral vision and it almost effectively is like you have blinders on.
And what basis, what's the source of the information that he gives you for that?
I believe it's going to be from the medical community and from other instructors that have undergone the same thing, from military and law enforcement studies, from officer-involved shootings, or from combat. It's going to be from a myriad of other sources.
And have you read any of those sources?
I have.
What are the specific sources that you've read?
One's going to be from Lieutenant Colonel David Grossman. He's retired from the Army. He wrote a book called On Combat and On Killing, and it expresses some of those same studies and statistics, also some of the doctors that he has interviewed or spoken with or read literature upon. And there's also articles that I read that keeps up with those sorts of things as well. There's just a litany of it.
Okay, in that specific study, how did that specific study document what was experienced with vision narrowing?
I would have to bring up the study. I couldn't speak on that from here.
Okay, and is that the source of your understanding of what happens with vision narrowing?
That's one of them.
And does that study indicate that vision narrowing is experienced the same for every person?
No, it does not.
So, and you testified earlier that you have experienced vision narrowing yourself?
Yes, I have.
And was your experience consistent with that study?
It was.
Okay. And that was the description you gave of being in a hallway with with a wall that you can't see beyond?
With walls on each side that
Walls on
you,
each side.
all you can see is what's between those walls. You can't see what's on the other side of them.
Okay. And for you, what was the trigger for the vision narrowing?
It was the first time that I was met with deadly force and I had to use it.
Okay.
And my heart rate was very elevated, and I was having to make critical decisions very quickly.
Did you experience it? So you said that was the first time you experienced it was when you were met with deadly force.
Judge, we're gonna have to go through every, the judges made a ruling about him being able to generally talk about visual narrowing. Is Mr. Gladden challenging that actually exists, that exists?
He was. He made an objection, so I'm allowing him
And Judge, under the rules, the state is permitted to inquire into the basis for the expert's testimony.
to. Go ahead.
So in your firearms course, you did not experience vision narrowing at that time?
I did.
So that was the first time you experienced it?
No, sir, it was not.
So you faced a deadly force situation before you took your firearms course?
No, it would depend. I've taken many, many firearms courses, and I had taken firearms courses prior to my first deadly force encounter.
And did you experience vision narrowing during those firearms courses?
Through some of them, yes.
Okay, so the first time you experienced vision narrowing was during a firearms course?
Yes.
And was that experience consistent with your experience in your first deadly force situation?
Yes, it was.
Okay. The other courses you said you received training on vision narrowing in addition to your firearms training. What were the other courses?
Through our advanced crime scene school, through going to multiple other trainings as it relates to firearms, as it relates to the shooting reconstruction course, all of that is mixed in there.
When you say mixed in there, in a crime scene reconstruction course, where is vision narrowing mixed into the training?
Because we're trying to establish whether during that simulated gunshot, during that training course, is plausible. Is it plausible from the standpoint of the person who had it if they say they experienced vision narrowing? And so that's brought in because you have to establish whether what's being taught and what you're seeing is plausible or not from the eyes of the person who's given the statement.
And previously you said that not everyone experiences vision narrowing the same way.
Correct.
You experienced it as a hallway with walls on both sides.
One time, yes.
How did you experience the other time?
The other time it was either narrower or it was wider. It just depends on the circumstances.
Okay. And did your training tell you how other people experience vision narrowing?
It did.
And what were some of the other ways they experienced vision narrowing?
Just as I explained it to you. It doesn't have to be in a deadly force encounter. It can just be in a situation that...
Oh, I'm sorry. I think I asked an unclear question.
Okay.
When I say in what way do people experience vision narrowing, how do people experience it other than as a hallway?
That'd be hard to say. I mean, narrowing is narrowing. I think you're just talking about different widths. It doesn't have to be a hallway. It can be a tunnel. It can be just blinders. It just depends on the circumstances.
So outside of your personal experience with vision narrowing, how do people normally see tunnel vision?
I can't really, I think I just answered that.
You can't say how people normally experience tunnel vision.
That's an unclear question. Do you mean what are the normal circumstances that they're under, where they experience it?
No, what do they see? When they have tunnel vision, what are they seeing?
They see what's directly in front of them and nothing in their peripheral.
Okay. So what you know outside of your personal experience is that tunnel vision means a person sees what's directly in front of them.
From my training experience and from other statements that I've received from people that have experienced it, yes.
Okay. Thank you, Ranger.
You're welcome.
Judge, I would just ask that the court limit the witness's testimony to tunnel vision to What he just testified is the extent of his understanding outside his personal knowledge. If the court is still going to allow that testimony.
You want us to limit his testimony as to how he has experienced?
No, Judge, that his testimony, that tunnel vision, that what he knows outside of his personal experience is only that tunnel vision means you see what's in front of you, and that there be no additional pictorial descriptions of tunnel vision and what that experience feels like, that he does not know outside of his personal knowledge, because the court has also already excluded his personal experience with tunnel vision.
Judge, he's just using lay language to just describe this phenomenon of what a person experiences, whether it's walls, blinders, tunnels. Mr. Gladden can't limit how he just is trying to describe to the jurors what that sensation, or what generally how it exhibits itself.
I think he was clear when he said that the person can only focus on what's directly in front of them. That is what you said, is that correct?
That's correct, Your Honor.
So we'll limit his description to that.
Thank you, Judge.
Okay.
To just that exact sentence, Judge, or can he explain himself? Or do you want to just that
What
specific?
more explanation to, I can only see what's directly in front of me?
Well, I mean, he talked about as again how tunnel visual takes place, what causes it, and then discusses the sensations. I just want to make sure he can lead up to that description as to give it context.
I think he told us a stressful circumstance can cause any one of these four reactions. Maybe I'm...
No, Judge, that's what I understood. And that's why I asked for clarification. If your ruling is that the ranger is going to be allowed to testify that in general situations a person may experience rapid heart rate, auditory exclusion, whatever we want to call the vision restrictions, and can also have short-term memory issues that may come back in time. If it's limited to just those general responses to a stressful situation, I understand the court's ruling.
Good.
Okay.
Most importantly, do you understand Ranger Armstrong?
Yes, Your Honor, I do.
Okay.
And Judge, just for the record, I know your ruling, and just for the record, I want to proffer those other opinions that I elicited in my direct examination of Ranger Armstrong with regard to the reasonableness of Ms. Guyger's actions and the basis for that. And we would, the legal analysis that was filed this morning would have to be part of the record to apply to this hearing as well.
The defendant's renewed objections regarding the exclusion of parts of Ranger Armstrong's testimony.
Right, Judge, that was filed this morning in relation to that initial hearing. I just want to apply that to this hearing as well, as the basis that we believe all the opinions that I listed should be admissible. Just for the record, Judge.
Okay. Well, for the record, I still have the same ruling of not. And I believe you said you had 3 experts that we needed to question and or qualify. This is number 2.
Right.
Is the other one not here? Understandably, since it's 5:30.
Based on your ruling, Judge, can we have overnight to reevaluate?
Absolutely. I'm glad you will let me go home. Thank you. And it's not a problem if you need to have a hearing tomorrow. So tomorrow being Saturday, we're going to start at 9 a.m. and we will finish at 4 p.m. at the latest. Okay. And then we'll go from there. We're not going to work on Sunday. We'll continue on Monday. So I will see y'all unless there's something else that we need to add to the record.
No, Your Honor. And I'm going to just accept that the court's limitations are going to apply to the state's experts, and we'll reevaluate tonight accordingly.
Okay, I'll see you all tomorrow.